Thank you for checking in on this somewhat impromptu webinar. This is a webinar designed for business owners and to a lesser extent, their counsel. This is a rapidly changing area of mergers and acquisitions. Benchmark, of course, provides no legal advice, and competent counsel should be sought for any type of binding transaction, particularly something as important as the sale of your business. But we do see a high frequency of deals here, and we talk with many buyers, and we have some insights into what's been happening with these PPP loans. And the reason this is such an important webinar is because we have several clients who have been concerned that when the time comes to close the deal, if their PPP loans are still outstanding, it would somehow interfere with the closing of the deal. We also have a few prospective clients that we've been meeting with who have expressed an interest in waiting to get the process started until they receive their loan forgiveness. It's been true since the beginning of the program that neither one of those concerns were really warranted. But fortunately, on October 2nd, the Small Business Administration came out with guidelines that address exactly how the PPP loans should be handled during the sale of a business in order to avoid any type of interference with the forgiveness process. And so that's what we want to talk about today. And if you scan the internet, you can see a lot of people kind of came out on October 2nd and October 3rd with their take on the SBA guidelines. But the reality is the guidelines are very short, they're very clear, they're very well written. They're 5 pages long with a lot of white space. And trying to make a synopsis is a bit redundant there. And what we want to do is wait a little bit and see the impact that the guidelines had, see how the market was responding. So although I am going to try to summarize the actual guidelines a bit today, the more important part of what we're going to speak about over the next, say, 20 minutes is actually how this is being implemented in the market, what effect it's having on the purchase agreement, the timing of deals, the allocation of risk in the deals, all the things that actually really matter. So with that in mind, we will get started. So what is the issue? The issue here is that the government created these loans that are forgivable, and pretty much everyone is hoping to get their loans forgiven. And there was just kind of an obvious concern. Well, if I sell the business before it's forgiven, what happens? So the PPP, or the CARES Act statute that created the loans was necessarily rushed to market, so to speak, without a lot of thought about kind of ancillary things such as what happens if I sell my business after I take a loan. As is common with statutes that come out, the agencies then exercise implementing regulations or guidelines is what's been done here. And so these guidelines don't have the force of law because they're not regulations, but they do explain how the SBA intends to view the forgiveness decision for a business that's been sold before the forgiveness decision has been made. And so this came out on October 2nd, and there's two pieces of good news about it, and there's no bad news. The first piece is that the guidelines basically tell people to do what the market had been doing anyway for the months leading up to October 2nd. So it's not really going to cause a change from what we're seeing before. It just provides more certainty, which is always a good thing. And the second piece of good news is that what the market was doing and what the guidelines call for is not onerous. It doesn't really interfere with the market for selling business. It doesn't really force much of a reallocation of risk between buyers and sellers. And we're seeing it add maybe 20 lines of text to a stock purchase agreement and maybe 10 lines of text to an asset purchase agreement. So it's pretty painless. That's the good news. That's the kind of the headline summary. Now, but what makes this really complicated is the fact that in almost all deals in the middle markets and the lower middle markets, the debt of the seller is paid off either before the closing or at the closing. It is exceedingly rare that an acquirer takes on debt of a seller. So here we have loans, they're technically debt, but everyone anticipates them being washed away, forgiven. So why would you prepay a loan that's going to be forgiven? You wouldn't. Nobody wants to do it. The sellers really don't want to do it. The buyers don't have any reason to want the sellers to do it. Now, leading up to the implementation of these guidelines, again, it's only 5 pages. It's pretty flimsy, lots of white space. The buyers had some doubts about things, and it was a little, sometimes it was a bit complicated. But now that the guidelines are here, the uncertainty is taken away. And so we have this unusual circumstance where loans are going to stay in place through the transaction. And that's the issue. So how do you do that? That's not a normal thing in mergers and acquisitions. And how do you do it without upsetting the potential for forgiveness? That's the issue. So let's go over the updated status. The SBA said basically, in order to prevent your transaction from interfering with the forgiveness of the loans, you have to do two things. Pretty easy, two things. One, you have to have submitted your application for forgiveness. And so all the clients that we've had, that are even in the first draft of a purchase agreement stage over the last, say, month, they have already got their applications for forgiveness in. So if you're at the point of closing a transaction, you do want to go ahead and get that application in. That's the first requirement. It's something you were going to do anyway, so that's not really an additional imposition. Our clients that have done the applications have, been a little bit upset, but it's government paperwork, but it's really not that difficult. And you'll want to check with your legal counsel. There are special provisions for loans that are less than $50,000 that make that process a bit simpler as well. So you'll want to make sure that if you qualify for that, you're using the expedited process. Sorry, the process is not expedited. The paperwork is reduced is the only benefit there. So that's step one, get your application. Step two is that the amount of the outstanding loan must be placed in an escrow with the lender. Okay, you can't pick another bank to set up the escrow with. It has to be with the lender, and it has to be the amount of the outstanding loan. And how long does the money have to stay there? It has to stay there until the lender is paid off, either by the borrower, which nobody, hopefully that never happens because the borrower is you, or by the SBA. So the SBA will, of course, pay off the lender once they receive your application, approve your application, and then pay the bank. How long will that take? That's something we don't know. But you can be sure the banks are going to be kind of screaming for that forgiveness, because they may have your money in escrow, but they can't really use it. And they want these loans cashed in as fast as possible. So you can rely on the banks and the banks' lobbying arms to really push the Small Business Administration to get those forgivenesses in pretty quickly. And we do know that some forgivenesses have already been awarded. I think it's pretty much kind of started about 1 week earlier. Today is October 27th. It started around October 20th. We started seeing a few approvals coming back. And so the good news is, even better news, I guess, is that if the approval comes back and the SBA actually repays the loan, all the things we're talking about today don't matter. Your loan is forgiven. The bank's been repaid. The debt's not outstanding anymore. So what we're really talking about here are businesses that still have the debt outstanding and are in a position to file for forgiveness. And pretty much at this point, we believe everyone should be able to file for forgiveness. All of our clients that are this far in the process have got their applications in without a problem. So that's the updated status as an overview. Now, to get a little more specific, you have to remember there's two sets of rules here. The SBA didn't give the loan to the business. A bank gave the loan to the business. The federal government, through the SBA, guarantees the loan. So these guidelines that we're talking today are the guidelines about how the SBA will handle forgiveness after an M&A transaction. And that's one set of rules. And the SBA has the discretion on how to treat those, not the lender or the bank. So the lender is going to also have rules about what needs to happen when you sell your business with a debt on it. And these are the same rules that apply to any transaction. But if you remember, I said earlier, typically, if not always, in M&A transactions for deals this size, the loans are paid off before or at the closing. And the bank, usually doesn't have a problem with that. But here we have loans that are going to stay outstanding. So your loan agreements or your indenture will need to be referred to see the set of rules that the bank is putting on you, as well as the rules we're talking about here that are coming from the SBA or the guarantor of your loan. So don't forget, you have to check the bank documents also. We don't want any surprises coming up at the last minute because, your attorney or, whoever's kind of helping you prepare for this kind of forgets, because you always pay off debt. So you don't usually dive into those documents and look at what's either called an assignment clause or a change of control clause. And we'll talk about why there's two clauses, but you really want to check that assignment and change of control. Okay. So there are three different ways that you can trigger these rules: a stock deal, an asset deal, or a merger. We're not going to talk about mergers. We don't really see those for companies of this size. They tend to be kind of bulge bracket, publicly traded types of deals. But a stock deal, so this is kind of a little bit of review for many of you, I'm sure, but in a stock deal, if you're a corporation, it would be called a membership interest deal if you're a LLC, or a partnership interest deal if you're a partnership. You, the individual, and maybe your fellow owners, you are selling securities. You're selling the stock or the interests or the equity in your business. So your business is not the seller, you are the seller. On the PPP loans, your business is the borrower. You are not the borrower. And thank goodness, when they set this program up, there are no owner guarantees required for these PPP loans. So in a stock deal, your entire company is moving over to a new owner, and everything that the company owns and every asset and every liability of the business can just stay there and move with it. So in a stock deal, your PPP loan is no longer your issue, unless the contract's worded very oddly, but typically it's going to just pass along with the business. And the SBA is kind of pushing for that to happen as well, because it says the borrower remains liable no matter what. So if the buyer would try to make you kind of assign the loan off to an affiliate or something, we're not seeing any buyers trying that, but that's not necessary. It's way too complicated. It's not what the SBA wants. So this loan will just follow along with all the other assets and liabilities of your business in a stock deal. That means that the buyer is then responsible for that loan after the closing date. Okay, that's a stock deal. In an asset deal, unlike a stock deal, you are not the seller. Your company is the seller, and your company is selling all of its assets, and it's going to either retain liabilities or it's going to transfer some of the liabilities to the buyer. And in an asset deal, the debt is not transferred. And the way the SBA guidelines are set up again, because the borrower remains liable, they're incentivizing everyone to not, in an asset deal, have the loan somehow assigned over to the new entity that's buying all of your company's assets. So in a stock deal, you're saying goodbye to the loan. In an asset deal, you're keeping the loan. When the asset deal closes, your company probably has two things: a lot of cash from the closing price that was paid, because it's going to be paid directly to the company, and this loan that's going to be left behind outstanding, and maybe some other liabilities. But for what we're focused on, that loan is going to stay with you in an asset deal. It's going away in a stock deal. That becomes important when we kind of get into the details here on the guidelines and the wrinkles that this is causing to deals. So the first thing what we need to know is, what exactly triggers this set of SBA guidelines? What if you bring a new partner into your business? Do you have to go through this process? What if you create a stock option plan for your employees? Or what if you just grant options to some of your employees under an existing plan? Or what if you sell off a division of your business? That's your business being the borrower. Is this something that we have to jump through these hoops for with the escrow and whatnot? And so the SBA was very clear on this. In the case of a stock deal, right, an equity deal, so membership interest, partnership interest, stock, if you are transferring 20% or more, then it triggers, it's what they're calling here in this document, a change of ownership. So that's deemed a change of ownership in the context of a stock deal, 20%. In the context of an asset sale, the trigger is 50% of the assets by fair market value. Not book value, but fair market value. Of course, then the third thing being a merger. If you do a merger, any merger would trigger. It's kind of only one way to do a merger. It's all or nothing. So that would trigger it. But again, we don't see mergers for this type of transaction. So we've done plenty of stock deals, plenty of assets deals, both before these rules came out and since the rules came out. And we've seen the implications of these things. And that's kind of what I want to spend the rest of the time talking about. Stock deals. What do we see in stock deals? So again, on a stock deal, you're saying goodbye to the loan. So again, you're going to make sure that your forgiveness application is in, and then you're going to, part of your purchase price is going to go into an escrow account with the lender, and afterwards, the buyer holds the loan. Right? On an asset deal, to the contrary, what's going to happen is you're going to keep the loan. Of course, you can contract around this and get into all kinds of odd things, but we're not seeing that happen, and we would strongly discourage that. You're going to keep the loan, but you're still going to set up the escrow, and of course, you still have to have your application in. So, what kind of protections? How is the existence of these loans and the fact that normally the loans are paid off, but now the loans are continuing either with the buyer or with the seller, depending on the type of deal. How is that changing the deals and the risk allocation in the deals? And we have to talk about it in the context of stock deal and asset deal a little bit separately. So in a stock deal, the buyer wants some protection because the borrower, as I said a couple of times, the SBA guidelines make clear that the borrower remains liable for the loan. And compliance with all the conditions of the loan. So if you didn't comply with some provisions of the loan and then you sell your business, the buyer is concerned that they're going to get tagged for whatever penalty arose from your non-compliance before the closing. And that may be that the loan is not forgiven. Well, guess what? There's an escrow now, so that's not really their big concern. They're more concerned about having some kind of penalty imposed or some kind of excess interest or otherwise falling afoul of the federal government. So what they're going to seek is a couple of representations and warranties in the purchase agreement that basically say three things. One, your application for the loan was complete, accurate, and honest. Two, your application for forgiveness was complete, accurate, and honest. And then maybe three, something along the lines of you're not aware of any reason why your loan would not be forgivable, or something along the lines of you used the funds for the specific reasons called for in the CARES Act and not for any other purpose. So we kind of we've seen the full range of what buyers are throwing into their first drafts. And another one of the documents that you'll find linked into this webinar is some sample language. And what we've shared there is not written by Benchmark. It's slightly edited, redacted versions of first drafts that we've received from buyers' attorneys. So we're trying to present you, the seller, with kind of the worst case scenario of what we're seeing in the market when it comes to, how's this going to change my purchase agreement? So you'll see in there a short version of the representation of warranty that the buyer asked for, and then kind of the longest version that we've seen that they've asked for. And when you look at those two, they're really asking those three things that I mentioned earlier. One of them's doing it with less words, the other one's doing it with more words. But that's not really a big issue for sellers because they're really just asking for specific promises that you did or didn't do something that's already covered by general promises, right? So there's already going to be a representation of warranty from the seller in every purchase agreement, that they've complied with all law, that they're not in default under any agreements. And these broader representations and warranties really cover most, if not everything, that we're seeing in the specific representation and warranty that the buyers are asking for. So it's kind of like when you get in the car with your spouse and you go on a vacation and he or she says, honey, did you lock up the house before we left? And you say, yeah, everything's locked. And then they say, well, what about the back door? Did you lock the back door? Yeah, I locked the back door. Well, you already really answered the second question the first time out, so you're going to be in trouble if you left any of the doors unlocked. And it doesn't matter that you got asked twice for the same question, you're still going to be in trouble, right? So in essence, this really isn't changing the risk, these representations and warranties. It's essentially kind of asking to double check on things. Now, you may come across one that's different, it becomes more onerous, but we are not seeing buyers trying to do anything offensive in this regard. It's really just kind of double checking those broader reps. And that's that, and then of course there's going to be the escrow language in the contract, and we've provided an example of the escrow language. It's basically one or maybe two sentences that get added to the purchase agreement to set up the special escrow. And then of course there'll have to be an escrow agreement drafted. Didn't provide any copies of those. That's a bit involved, but we're not seeing any wrinkles come out of the escrow agreements. They're very straightforward. So in a stock deal, the buyer needs that protection. In an asset deal, what protection does the buyer need? Not so much, because the seller is keeping the loan. So we don't really see much in the way of changes to an asset purchase agreement in terms of protecting the buyer. Now let's flip the coin and see what kind of protection you are going to want to ask for in the deal. And we didn't provide any examples of this. This is something that your legal counsel will help you with. Again, the little handout we've attached really is trying to show you the worst case scenario of what buyers are asking for, because it's simply not scary. And now we're talking about protecting you. What do you want to put in to protect yourself? Well, in an asset deal, so we'll just talk about that briefly. What do you need? You don't need much. You're keeping the loan. There's not much the buyer can do to mess up your forgiveness. So in an asset deal, we're not really seeing any additional protections required for sellers. In a stock deal, however, you passed the loan along, and it's your money held in escrow that's going to satisfy that loan if something goes wrong and forgiveness falls through. So the sellers are asking for some covenants from the buyer to say that they will not do anything to interfere with the forgivability of the loan, that they will notify the seller if anything happens that may interfere with the forgiveness of the loan, that they will provide any notices about forgiveness or communications from the SBA or the lender back to the seller. And pretty simple stuff. Again, it's imposing a little bit of a burden on the buyers there. But the buyers don't seem to be balking at that in our transactions because it's fairly small. So those are the differences. And just kind of, I use some terms that I want to make sure everyone understands. I said to protect the buyer asked the seller to give some representations and warranties. And then I said to protect the seller will ask the buyer for some covenants. Well, what's the difference between representations and warranties and covenants? A representation and a warranty can only address what happened in the past or what is currently happening. It can't address the future. A covenant can only address the future, not what's happened in the past or the present state of affairs. So that's why the seller asks for covenants about what's going to happen after closing or not happen after closing, and the buyer asks for representations about what happened before closing or maybe at closing. And again, that's really only in stock deals. And asset deals, what the language that we're seeing besides setting up the escrow is basically two sentences. In the definition of excluded liabilities, the parties will make clear that the PPP loans are excluded liabilities. And in the indemnification clause, the parties will clarify that the indemnification also covers anything arising from the PPP loans as a result of something prior to closing. And those, again, are kind of like, honey, did you leave the back door open? They're really just repeating general obligations and facts that are already there, but just to try to make sure there's no surprises and everyone understands. So as I said earlier, in a stock deal, we're seeing maybe 20 lines of text being added. And in asset deals, we're seeing maybe 10 lines of text being added. Very minor reallocations of risk. It's not slowing down deals. It's not driving up legal fees. To the extent, before the guidance came out, there was a little bit of back and forth that might have slowed things down a couple days and cost a few extra dollars. But now with the guidance coming out, it's very clear. They're very well written. People are burning right through it. There's really not kind of market language yet, and hopefully this will be over before there's enough examples to say that there's a market set of language, but the variation of what we're seeing is all within a very narrow bandwidth, and so it's really just not causing any issues. So there are a few minor wrinkles, however, and again, this is something that nobody would have necessarily known on October 2nd when the guidance came out, but a couple of things that we're now seeing. The first one comes around the how indebtedness is handled in the purchase agreements. So in any purchase agreement, stock or asset purchase agreement, there's going to be a definition of indebtedness, sometimes debt, but almost always indebtedness. And it's a laundry list of things that might be 12 to 20 commas long. And the natural tendency is that the PPP loans would fall within that definition. Okay, fine, that's kind of a fact, but how is that definition used? And that's the wrinkle. So in almost every transaction, the seller has to say there's no indebtedness as of the closing, or if there is, it will be paid off at the closing. And to the extent there's any indebtedness that is in place after the closing, the buyer can reduce the purchase price dollar for dollar. Okay, so if the documents are being drafted and people are just kind of, what I just explained is just so common, right? They're not thinking through, right? And they don't mention the PPP loans in terms of indebtedness. Suddenly, you as the seller not only have to set up the escrow, but you also have to pay the buyer dollar for dollar for the amount, and that's clearly not what anyone intends. So some care has to be taken. So we've seen some first drafts come in where either the PPP loans are not addressed, and we've had to say, hey, seller's counsel, please address this issue. We've seen other cases where the PPP loans are expressly included in the definition of indebtedness, which makes it's the same outcome, but even worse. And that's just not right. So these agreements need to be tweaked when it just, the attorneys need to follow through how indebtedness is handled and ensure that the seller is only being penalized for the loan by the escrow and not in any other way, shape, or form. That's the first of the three wrinkles. The other two have to do with the actual wording of the guidelines. Like I said, the guidelines are great. They're not causing any problems, but there are two specific types of deals where there may be some ambiguity that would require you to really drill down with your legal counsel and figure out what's going on. So the first of those has to do with the stock deal. Second one's going to do with an asset deal, but the first one does with the stock deal. I mentioned earlier that what is considered a change of control, or sorry, change of ownership is the term, and that is the sale of 20% or more of the equity. And I shouldn't say sale, I should say transfer of 20% or more of the equity. That's what it says on page 1 of the guidance. And then on page 2, I think it's section 2A1A, it makes reference to 50% of the equity. So if you're doing a transaction between 20% and 50% of your equity being transferred, you need to be very careful. Discuss with your counsel, why does it say 20% on page 1 and 50% on page 2? What's the difference? I don't think it's actually a mistake. I think it's actually a very technical distinction, but you really need to buckle down. We have a tendency when we see 20% the first time, our eyes will show us 20% the second time, or if we see 50%, we will think we see 50% the second time, but it is actually 20% and 50%, and that needs to be addressed. So we don't see many deals here between 20 and 50%. We haven't not had this issue come up in the last, since the guidance came out 3 weeks ago, but that's kind of one area where you need to be careful. The third and final wrinkle has to do with asset deals. I mentioned earlier that a change of ownership involving assets is one that involves the transfer of 50% or more of the assets by fair market value. So they've gone a long way towards making that very clear, but there's two issues that may come up. Again, most transactions, it won't come up. No one sells kind of around 50% of their assets. It's pretty much going to be all or substantially all of the assets. But if you're in this world of selling some but not all, you will want to drill down with your legal counsel very carefully, because two things. One, is that assets or net assets? So if you're selling 55% of your assets and you're transferring along 10% of your liabilities, is that 55 minus 10, so it's 45 and it doesn't apply? Or do you not get to net the assets out against the liabilities? It's not entirely clear. And another thing that's not clear about is in an asset deal, you're hopefully not selling your assets for just the fair market value of the assets, right? The camera and the microphone and the keyboard. Hopefully you're selling it for something more, and that more is called goodwill. And so if you're selling 50% of your business, are you selling the goodwill or not selling the goodwill? Does it count towards the 50% or not count towards the 50%? What if you sell, 55% of the hard assets, but you're keeping your name and your URL? Well, that's a big part of your goodwill, but the fair market value of the name and the URL might be very low. It's very so that goodwill issue is something else. Again, speak to your lawyer. Probably on that one, speak to your accountant also. But again, the vast majority of deals don't fall afoul of either one of those two minor wrinkles. And again, this is pretty straightforward stuff. It's not impeding the markets. But just to kind of round this out, I want to make sure I bring up some of the other requirements that are in there. So there are certain requirements that you disclose paperwork to the lender about the deal. So there's, it doesn't really change anything. They're probably going to want it anyway. But make sure that you and your attorney look at those requirements as well. What exactly do we have to give the lender? And secondly, there's an obligation that within 5 days following the sale, the lender must notify the SBA and provide some of the final paperwork to the SBA. So you'll want to make sure that that gets taken care of. I could see that being a kind of a mutual covenant in the purchase agreement, that the parties will cooperate to make sure that that happens, or maybe one party will take responsibility for ensuring that it happens. So you just don't want to overlook those other minor requirements. Conclusions. So the conclusions are as follows. You can sell your business when you have an outstanding PPP loan, and just because you have the loan, it is not going to make your deal substantially more complicated. You will want to get a start on getting the forgiveness application in, but once you get that application in, you have complete control over the ability to sell your business. We are not seeing it affect valuations. We are not seeing it affect the size of the legal bills. We are not seeing it affect the amount of time it takes to get to closing. If for some reason you can't comply with these the strategy we've talked about here, you can still close the deal and seek the SBA's approval. If you follow the procedures that I've talked about for the last 20 minutes, you don't need SBA approval. But if you can't do that, there's also a mechanism in the guidelines for obtaining the SBA approval. Nobody wants to put their deal in the hands of a third party, especially a government agency, and then kind of sit around waiting for something that you can't control. But that option is out there if it's absolutely necessary. We've not yet had to use that with any of our transactions, but it is an escape hatch that's out there. So those are the conclusions. I'm Clinton Johnston, by the way, here at Benchmark. I don't think I said that at the beginning, and I'm keeping my finger on the pulse of this issue. If you are a client of ours, the transaction directors are in constant communication with me about these loans. If you have any question, you can ask them to refer to me, and I will always have the latest and greatest information on it. If you're a prospective client and you're meeting with some of our people, they also are in regular communication with me. And if you have any question that they can't answer about how these loans might affect your ability to sell or go to market, ask them to get in touch with me. I'm always available for them as well, and happy to answer any questions that come up in the future. In the meantime, if you're interested in getting to know Benchmark a bit better, you'll see my colleague Wade Duncan's contact information somewhere in the file with this webinar that you've clicked on. And please reach out to him and learn more about Benchmark. And thank you very much for joining us.